The battle over social media and whether it is affecting the brains of children and adolescents may end up being settled in the courtroom. On this episode of Today in Tech, we're chatting with one of the attorneys who was part of a multi-district lawsuit against the big social media companies to explain the case and what it means for the future of social media. Hi, everyone. Welcome to Today in Tech. I'm Keith Shaw. Joining me on the show today is Jane Conroy. She's a partner at Simmons Hanley Conroy, a national law firm. She oversees practice areas in the complex litigation department and is involved in the multi-district litigation of social media companies and whether the platforms are addicting to younger users. Hi, Jane.
Good morning.
It's an honor to have you on the show. I really appreciate that you took the time to talk with us about this. Before we get into some of the questions, I do want to read the allegation of this lawsuit. Basically, they are saying that social media platforms are defective because they are designed to maximize screen time, which can encourage addictive behavior in adolescents. As alleged, this conduct results in various emotional and physical harms, including death. And defendants in the case include Meta Platforms, which owns Instagram and Facebook, ByteDance, which owns TikTok, Alphabet, which is Google and YouTube, and Snap, which owns Snapchat. So before we get into it, can you explain what a multi-district litigation is? And I think we'll just refer to the rest of it as MDL. How is this different from a class action lawsuit or other types of lawsuits that people may have be familiar with?
Sure. And it's kind of crazy because a lot of what people are familiar with are actually multi-district lawsuits, or MDLs, although I think a lot of us shorthand them into saying class actions, but they're actually not class actions typically.
Right.
But what happens in the federal court, you may have a lawsuit in federal court in Massachusetts, and I may bring one in Illinois, and 50 people may bring one in federal court in Texas. And rather than have all different decisions from different judges in different federal districts around the country, there's a panel of judges that actually makes a decision whether a case is broad in scope enough or involves enough federal districts that it would make sense to give one judge the ability to oversee the case. It doesn't mean that that judge tries the case, because we still have a right to a jury of our peers.
Okay.
And if I bring a case in Massachusetts, I'm entitled to a jury of my peers in Massachusetts. So the multi-district litigation assigns a judge. All of the cases find their way to that judge through different legal processes. And then the judge picks, and this is another kind of weird thing we don't often hear about, the judge picks a group of plaintiff lawyers from around the country to actually prosecute that case on behalf of all of the plaintiff lawyers that have brought the case. And so you work through all of the details in the case, and we'll talk about some of those today with social media, but
Sure.
This is what's happened in opioids. It's what's happened in the BP oil spill. It's what happened in the Volkswagen diesel issue. Happens all the time, but we don't often think about it, but it's a very efficient way of dealing with a huge case so that you get sort of rulings that are somewhat uniform, at least.
Does an MDL prefer or have not prefer, but does it succeed in one? Like, who's more happy about an MDL, like the plaintiffs or the defendants, or is it beneficial for both?
I think the defendants are usually happiest about an MDL because if you think about it, if you don't have something like that, and you're the CEO of Meta,
yep,
you have to give testimony in every state, every courtroom.
Right.
This puts it all in one place. And for, plaintiffs, we like sometimes the chaos of a case being all over the place, but I think defendants, it's beneficial for defendants, but it's not so bad for plaintiffs either.
Okay. All right. And one other thing about MDLs I want to ask is most of them need to have a legal theory that establishes their main argument. And so in the case of this one, it's pretty unique. Can you boil down the legal theory about social media and how you're attacking them on this? Or I don't say attacking, but how you're approaching the case?
Sure. And to kind of step back a minute.
Yeah.
An MDL is just a collection of lawsuits that have been filed. So if you file a lawsuit in the United States, it has to have a legal theory that is supportable.
Right. So that's not just that's not unique to MDLs then.
Yeah, the MDL doesn't give you any kind of a leg up on that kind of situation. But this case sort of boiled down to its very essence is saying the social media companies were well aware that the way that they were setting up Instagram or YouTube or any of the other platforms that people could get onto, they were well aware that they didn't have protections in place to protect against minors getting onto those platforms if they shouldn't be there. And they also developed algorithms, which were sort of behind the scenes formulas that would help and assist company like Meta in saying, oh, here's the information from a person in Illinois, and we think it would be useful to let that person also have access to other platforms without the same kind of, again, without any safeguards used. So that's basically the theory is, I'm trying to liken it to sort of any kind of a theory about something being defective because the warnings were not adequate, defective because profits over safety were issued, but it's basically a product's liability theory.
And usually when you hear about product defect cases and things like that, it's usually around a product with a hardware, it's either hardware or it's a physical object. And in this case, this is all software, right? Like they're starting to talk about software. Has that been done before, or is this unique in that we're
I wouldn't say it hasn't been done before, but we're deep into it at this point. So this is our new frontier, because you're right. When it's a hip device and you say, hey, you didn't warn me that it was only going to last for 3 years, or you didn't warn me that this metal was going to corrode in my body, that's easier to appreciate because it's a product. Here, it's not something you can hold in your hand. So it creates, you got to do that little mind leap a little bit.
Right. Okay. I in our discussions before the show, we had talked about Congress and some of the governments being able to how much of an impact would they have? And of course, now recent news was that Congress is moving forward on legislation that could effectively ban TikTok. And that's one of the companies that are involved in this lawsuit. Will that have an effect on this case at all? Or do you have to monitor this as it's going along as a potential veering point or something like that with the lawsuits?
Well, I don't see it yet as something. I mean, yes, we monitor it because it's, because TikTok comes up.
Sure.
So you look at it. But I don't think it really impacts. We see in so many of the cases that we deal with, Congress is likely involved. Congress may have congressional hearings about issues that we're involved in. Congress may be amending or tweaking laws that are already in place. If you take, for example, the opioid litigation, the Controlled Substances Act was basically the cornerstone of the opioid litigation in this country. Congress had enacted that. They had lots of hearings on it, but it took the courtroom to actually, evaluate whether or not companies were following the Controlled Substances Act. So whether or not there's a discussion about banning TikTok, it could be interesting. We may hear some interesting things or hear some testimony from the companies about it, but it doesn't impact our case, which is saying our case is just a whole bunch of individuals who brought complaints, and whatever has happened has already happened to them. Right.
Okay. And so what another interesting part of this MDL is that a group of state attorneys general, I think it's now more than 30. I'm not sure what the latest numbers is, but and even other public governments such as school districts and groups like that have joined this MDL. And this is unique, right? Usually those groups kind of stay away from those types of things and try them separately. Do you have a reason why they may have done that? Do you have a thought of why they've joined this
Sure.
one?
And obviously I don't know for certain, but there are two things that are, well, there's one thing that's very unusual about it. When a state attorney general brings a lawsuit, they are entitled to bring it in their state.
Sure.
So it's a big decision to say, if you are the attorney general in New Hampshire, to say, I think I'll let a judge in California prosecute this case for a while, until it gets sent back. So that's a big deal just on its own. I think what we learned in the opioid litigation, which is still going on and still sweeping, we had sued on behalf of governmental entities. And we saw also in the Juul litigation where it was school districts that brought litigation.
Okay.
The states were involved. Some of the states already had their own state court cases, and they recognized, I think, as we got into the litigation, it was much more powerful to join forces with the other plaintiffs, like school districts or cities or counties. And here, I think the state, so we had a good experience in opioids working together with the attorney generals, because we as lawyers representing individuals, I can't get Meta to change its practices. I can only get, we call it money justice. I can't change the pain and suffering, but I can get monetary recovery for somebody. That's all I can do. They can keep doing the same stuff the next day and just kind of factor in what it might cost them if someone brings a lawsuit. The attorney generals can actually put in injunctive relief, which is a very powerful tool. So that happened in the opioid litigation. That happened in the Juul litigation. And so you are seeing, this is, I would say, the issue of sort of software and how it fits into defective products. That's a new frontier. AGs and private lawyers like my law firm and others all banding together, not necessarily brand new, but on a huge scale like this. Yeah.
And it also shows the impact of something like this, because you've got 30, which is a majority of the states in the U.S. So it's not like you've just got only one or two states attorney generals on your side. You've got a big majority.
Well, if you think about it, when everybody refers to the tobacco litigation, a million years ago, that was only 11 states.
Wow. Oh.
Only 11. So 30 is enormous.
Well, I mean, there was probably a lot in the South that didn't want to get involved in that because it was such
exactly.
A cash crop for a lot of the people down there. All right. So the MDL cleared its first hurdle. This was the presiding judge in the case did not dismiss the case outright. So what are your next steps now? Because that was a big ruling, right? They could have just the judge in this could have just said, nah.
I don't. She could have. She could have said, "I don't think your theory holds water. I don't think, I don't think you can bring a claim. I don't think you'll survive. All of those things." We did clear that. Also, that decision. Judges could also just say it's a motion to dismiss filed by the defendants. The judge just could have said denied.
Right.
And we would all be like saying, "Well, great, we can go forward, but we don't really know what she's thinking." It was a long order, clearly written out, which really gives us a roadmap of what she thinks the way the case will progress. We already have case management orders in place. So we are receiving documents, hundreds of thousands of pages of documents. We are organizing to begin to take oral testimony in the form of depositions. So once you clear the hurdle of the motion to dismiss, you're off to the races. You're like, okay, now we actually have a real lawsuit. The court says the legal theory is, the court isn't saying you've proven your legal theory.
Right.
It's saying, you have a theory to go forward with, and now we'll see if you have the evidence that a jury will agree supports the theory.
Okay.
And so that's where we are now. We're starting up, and we're doing the day-to-day basement work, looking at every document, looking at the emails, fighting about what we have access to, fighting about what we can make public,
And then that's part of the discovery process, right? For both sides.
Yep.
Okay.
And also the defendants will begin the discovery of the states, the AGs, what they've been doing in their own states.
Yep.
as well as our individual clients. Tell us about how your client became addicted. What kind of addiction? Where, what do you have for proof that there's addiction? So it goes in both directions.
Right. Now, we also discussed about before the call here what the issue of bellwether cases, and I wasn't familiar with that term as much. But what is a bellwether case? And because again, you've got multiple different lawsuits that could be tried here, so you also then have to decide which one is the first group, I guess.
Sure.
Yeah.
And I'll go back to sort of like an easier thing, like a defective hip case that has an MDL. And let's say you have 600 individuals that all got that defective hip and have a problem with it. They brought a lawsuit. They survived the motion to dismiss. The court can't try 600 cases.
Right.
It's impossible. So what the court will say is typically, and there are a few different procedures that can be followed. Plaintiffs, pick 10 of your cases you think represent the 600. Defendants, you choose 10 of the 600 that you think are representative, or in other words, that you think you can win. Plaintiffs, you pick 10 you think you can win. Defendants, you pick 10 you think you'll win. And the judge then sometimes may say, and I'm going to then pick 4 out of that group of 20 or whatever it works as. There's all sorts of different ways that it's done. But the bellwether cases are those cases that are selected to go forward, pick a jury, get a decision, all of that sort of, basic legal work that looks a lot like what we're familiar with on TV. It's a real trial, and that's what we think. And we hope that those bellwethers inform us in some way, that maybe a jury, maybe the plaintiff picks the best case they think they have, and the jury's like, we're not buying that.
Sure.
That tells you a lot about maybe the other, 599 cases.
Right.
So,
right. And so will those bellwether cases be the first wave that we see in this case? They will.
They'll be chosen. The court, we're not certain yet how the court will select those. And this is probably, I don't think it will happen this way. Sometimes courts try to pick certain issues. Like they may say, we're going to look at the individual cases first, and then we're going to go to like a state AG case. She may phase it like that. It's hard to know what she may do, because what she's trying to, the judge in this case is trying to, I assume, is get her arms around the cases and put her time into trying a case that leads us to some decision about what a conclusion in the case would look like.
Now, these bellwether cases, will they be tried in this? Because you keep saying she on the judge. We never identified her.
I'm sorry, it's Judge Gonzalez Rogers.
Yep.
In Oakland, California, was identified as the court.
And so, will these cases be tried in California, or will she say these are the cases, and then you can go back to whatever federal district that you initially wanted to do?
We typically won't go back to the original federal jurisdiction.
Okay.
You are entitled to a jury of your peers.
Right.
The defendant is as well. So if the plaintiff in the case is not from the Northern District of California, then it really can't be, unless the defendant agrees and the plaintiff agrees to, like if you're from Oklahoma and both sides say, yes, we're going to let the judge try this Oklahoma case.
Okay.
It won't be chosen as a bellwether. That's really kind of in the soup of trying to figure out what a bellwether should be, but there are protections on both sides as to whether or not your case gets tried.
Okay. So as we move forward, so now we have a sense of where this is in the process. What are the chances that companies, especially in the social media side, might just look at these cases and go, I think we're going to settle, or they want to kind of get it before it gets to one of these big trials? And because again, trials are risky for both sides, right? And so what do you think that this might happen? It feels like we might still be too early for them, like they're ready to roll the dice.
I think we're too early for sure. I don't think they're stunned that they lost the motion to dismiss.
Okay.
Because that's a pretty powerful and supportable legal theory. It's one of the problems with cases that are this large and frankly pretty new. And this happened in the opioid cases as well, because it was the first time you used public nuisance across the country for something like a drug. It's hard to know how to end the case. Even if the defendant says, we'd like to settle, which they're nowhere near that. So I don't mean that they are in the social media case, but even if the defendant says, okay, you got me, I want to settle, it's really, really complicated to figure out how to settle the case. Because if you're settling it for money, who gets the money?
Right.
Do the states say, thank you very much, we'll take the money and we'll do what we need to do with it, and we'll put programs around the country? And if I represent an individual, I'll say, no, my client needs money for addiction therapy and rehab and that sort of thing. So it can be really thorny how to maneuver, even if both sides want to settle. It can be very tricky, and so that's something that will come about. But what isn't so hard is as the evidence develops, and if we show, for example, that the companies well knew the age of a minor, they knew someone was a minor when they signed up, and they lied about their age, but because of all of the other data they collect, they know that kid is in 8th grade, and we can prove that they knew that kid was in 8th grade. Then those are the kinds of things you may see the state attorney generals or even the court suggest. You need to immediately change your practices. You need to warn people either that you're not checking for age. You need to tell people that. Or you need to, if you tell parents, you can track your child's screen time, you can track where they're going. If you say that, you have to be sure that it's possible for the parent to actually do that. Yeah. And the court or the companies themselves or the state AGs can force that, can say, we are forcing you to tell us, and we're going to monitor whether or not you are checking the age or giving proper instructions for how a parent can check screen time. So there are things that can happen in our case that could change the way these companies practice. And from the company's point of view, the company may say, we're willing to do that, but it's going to cost us $8 billion to put in the software that's going to train parents how to, monitor screen time. Right. So we want a break if we settle the case. There's all sorts of directions it can go in.
I want to jump back a little bit and ask you about how did these lawsuits start kind of bubbling up, and how did you start first getting involved? What was it that was like the point of like, oh yeah, we've got a lawsuit here? Because obviously it's not like you guys just go running around going, I want to figure out who I'm going to sue, and et cetera, et cetera. There's a process before you guys even file that lawsuit, right? So what was it that you were hearing in the space, or potential clients coming to you, that made you go, yeah, this is a case we want to be involved in?
There's a very long process. By way of example, in the opioid litigation, that litigation started in 2000, and it took a long time as addiction medicine became more sophisticated and such, and you better understood marketing and the data that's available. Building on that availability of data, we began also in working with many of the addiction experts that we were working with on opioid addiction, and frankly, smoking addiction, and in Juul becoming addicted to, vaping and things. We began to be much more aware of other forms of addiction that we were seeing. And we were also in Juul dealing with school districts, and even in the opioid litigation, a lot of the conversations we were having with communities was the difficulties they were having in their school systems, and whether it was they needed Narcan or whether they were having, you talk to teachers, you talk to principals, and they lay out all of the issues that they have. They're not just solely focused. And we just began to hear more and more. you get many more scientists and medical doctors that have money now available, because it used to just be the companies that did this kind of investigation.
Sure.
That have money and grants available to look into addiction and what's happening in a minor's brain if they're spending a lot of time on the screen. We're seeing schools making evaluations, particularly during COVID, when kids are looking at screens all day. You have a lot of studies coming in. So it percolates up to us. The kind of law firm that I have, and there are, a dozen or more law firms around the country that do these kind of plaintiff large litigations. And very often, this happened early in the opioid litigation, there might be a parent who's also a lawyer who doesn't do this kind of stuff at all, but just is like, something's wrong here.
Right.
I got to figure this out. So cases percolate up in that way, and they finally reach a critical mass where you're saying, I'm hearing a lot about this. I'm reading it in the medical journals. I'm seeing it in the newspaper. I'm watching congressional hearings because people are concerned about this. And that's when we start to look and say, okay, I see the problem. I see the damage. Is there any legal theory that can bring this issue into a courtroom?
Right.
That's where people struggle with climate change. That's a giant issue.
Right.
How do you get it into a courtroom?
Sure.
That's trickier.
Now, in a lot of these cases, especially so you're representing the plaintiff, you're on the plaintiff side on some of these cases. You must be pretty confident that you have a lot of evidence that will support these complaints. Obviously, if you're a lawyer, you got to have evidence in your little bag. And we hear the term smoking guns. Do we have that kind of evidence yet? Or is that something that comes up during discovery, or does the discovery process all of a sudden you now have another pile of documents that support your argument?
You hope for another pile.
Yeah.
we do have smoking gun documents that come from Europe, because Europe is typically a little further ahead than the United States on these kinds of issues. So there have been documents that have been made public in Europe that we have that we consider smoking guns. And another thing happens after years and years of doing this kind of work, suing large corporations that are profiting from whatever business they're in. They all kind of work the same. You sort of see the same sort of things. You see corner cutting and different marketing ploys that, maybe the marketing guys really weren't talking to the research and development guys, because those two diverge wildly. So you kind of get a sixth sense for when you think there's likely a problem.
Right.
So we have smoking gun documents. We will get many more smoking gun documents.
Yep.
We will wage a big battle on making those documents public.
Yeah.
They do become public at trial, which is what we always work for.
It feels like you guys were helped by the whistleblower testimony. You get whistleblowers at some of these companies that then produce documents that were supposed to be private, and that things like that. So that seems like, how much of this information do you believe will be made public during the case?
Well, I know the defendants will fight for none of the information to become public. We always fight those battles and say, what is confidential about this? What's confidential about this marketing PowerPoint that you showed at a conference to 100 people or something? We fight those battles, and sometimes we win, sometimes we don't. Sometimes, even if we win it, it doesn't really have enough context to people outside. Smoking guns to us are sometimes a little, they need some explaining. So, I don't like lay out a whole case, but it's kind of a mixed bag. But as soon as you go to trial, when trials are public, it's a public forum. So when I show a document to a witness, it's shown to the world.
Right. Okay. we have a lot of audience members that are into technology, and they probably use a lot of these social media tools. And I think we were talking to some other guests about the dangers of social media. We're going to have some psychologists on the show and things like that. And a lot of them are like, yeah, there's benefits of social media, but then there's also this bad side. So they want to raise the awareness of the bad side things of too. But audience members, if some of them are parents, what should they do around understanding of this case? Should they just kind of watch it and see where it goes? Can they become more active in this? How can audience members get involved as this process goes through?
I think one way is the case is pending in the Northern District of California in Oakland, and there is a website for the case. And so people can follow and read the judge's order, which actually is very readable and very understandable. So people can follow along and can really appreciate, because even in that order, we laid out what we felt could be done better. And it's referenced there.
Right.
And I think that would allow parents to understand how far they can go with this. First of all, to recognize the dangers to minors, but also it might inform people about the types of measures they can take to. We say that the ability to look at this, how many hours someone's on the screen is flawed, but it's something, right?
Right.
Something people can do. So there are, I would say, the case website, and then just reading articles about it, what you yourself are doing, just raising awareness that it in the growing brain of someone who's, between 10 and 17 or 18 years old, there are things going on that science and medicine may not be fully aware of the total mechanisms, but we know that there are things happening in the developing brain that are impacted by this kind of singular screen time.
Yeah.
And then there's the secondary piece, which is a parent may have no idea of the risks that their child, just where they are, where they're going, what websites they're looking at, where they're being directed by the algorithms. We know that the companies know where they're being directed because they wrote those algorithms, and they want people on their phones or on their screens for a longer time. That's the game, right? That's what you want. Keep them on their electronic devices. So these algorithms are intended to do that. So once you recognize that, and we all talk about these things, right? Like, oh my God, I just talked about, going to Cabo, and oh, that's weird. It's coming up on my Instagram.
Right.
We see those. There's a reason for that. And so I think awareness is one huge issue. I think awareness of addiction has changed in the last 20 years. I think people felt addiction was a choice. And I think now they're recognizing that's not the case anymore.
Right.
So,
right. Yeah, we're gonna have a link in our description. We're going to include links to the both the initial complaint that was filed for the MDL, but then also the judge's first decision, and within a lot of these, there were some things that I didn't even realize, like, for example, some of the different tools that these companies use to keep you on the device, such as, like, there was one app, I think, that hid the clock so you would have to get off and then either look at your watch or re-click the phone to say, oh, what time is it? Oh my gosh, I've been doing this for 45 minutes. And and that felt to me like what happens in a Vegas casino where they don't have any clocks on the wall. And those types of things. Again, they're trying to get you to do something for a long, long, long period of time.
And maybe, what I would say, maybe hiding the clock is not going to win the case, right? It's because you could be aware of that and people could learn it. But when you add it up with everything else and the way things are working, if they know to hide the clock, they probably know how to manipulate your 12-year-old.
Right. And so there were a lot of those examples in the complaint, and I think also in the judge's decision that was like, this, I find that this was valid, but then the companies look at this and then they make changes. So I think that the clock thing may have been a TikTok thing. And then the last time I was on TikTok, I couldn't hide the clock. The clock was now there. And I think TikTok enabled a time monitor that says, a little pop-up comes up and says, hey, you've been doing this for 100 minutes, but then you could just hit dismiss and you're like, I'm going to keep going. But as companies hear about these implications that what you have, does it make it a difference that they've now fixed it and made it a little bit better, or they're trying to make it better? It doesn't have any impact on your case, though, right?
Well,
or does it say like, oh, well, we've now proven that you guys did this because you fixed it?
Exactly, because what we typically say is, oh, you said it was impossible to do that, or you said it was going to be really expensive to do that, and look, it took you 4 days to right. to do that. So it typically helps us. And look, the goal of this is the goal writ large is to make this safer. So yes, that's a good thing when the clock shows up. And yes, I want these companies to change their practices. So it's a good thing when they actually do that sort of thing. But it also tells me, hit a nerve.
Yeah. But they still have to be responsible for that activity that they did before they made the fix, right?
They're definitely responsible for that activity before. They may be responsible. They may say the best we can do is fix the clock. We can't do anything about, it gives us, it all gets played out as to what it is. But I look upon those things, even though I think they typically help me in a litigation when companies do that, I want them to do those kinds of things too, because it is going to make it safer. And
you've given a lot of examples here in other lawsuits. You've talked about the opioid crisis. You've talked about the hip replacement ones. And those are some serious big time cases. Do you think people understand that this is approaching that level and that this is a really major serious case? Or is it, is there more awareness that has to be made about about these addiction issues?
There will need to be more awareness.
Yeah.
It's not, this case can't be put into sound bites yet, which makes it hard for people to really appreciate what's going on. If you look back on opioids, we filed we started opioid cases back in 2000, but the first foray on behalf of cities and counties was in 2016, but it wasn't really until 2020, 2021, that people actually started to recognize that it was a case and that there was going to be a jury and there was going to be a decision. It takes time to pull a case together and for there to be, and it's a tricky, you get a lot of defendants, you get a lot of theories. It's not easy like the train derailment case. We all watched it on our TV.
Right.
And there's a lawsuit, and we know that'll either settle or it will end up at a trial.
Right.
This has lots of legs,
Right. So, you've given a lot of dates before on previous cases, and so we understand that this is a long process. What time frame are you expecting to see with the social media cases? Is this going to be dragged out for another 10 years, or is it going to eventually, or to be quicker? Because of the technology, because technology advances so quickly too. Like, does this get sped up or no?
We're on a good track. So we're looking at a trial as the documents are being produced and such. We're looking at a trial of the first bellwethers, of which I don't know what that phase will be yet, in next winter or spring, which is nice and fast. And our judge is, when MDL judges are appointed, the panel that chooses the judge looks at how busy the judge is and how much they can handle. So all of that factors into how fast you can move a case. So I think this case is moving very quickly. She issued her decision very quickly. She sees us at least once a month, sometimes once every 2 months. We're in her courtroom in front of her, and she's asking really hard questions and saying, why didn't you do this? And when are you going to do that? So she's got our
Okay.
finger on us.
And is this a case where there's an end goal in mind? Because again, you've got multiple different end goals. You've got a potential consumer that wants a financial restitution. You've got these attorney generals that might want legislation around certain things. You've got, other types of people that might want a different result. Is that a good thing in this case, or is that something that adds a more complexity and potential other hurdles?
It certainly adds complexity.
Yeah.
But you can simplify that complexity by focusing on what will be, for example, what will be the bellwethers, right? And if the bellwethers are an individual case, we're going to focus on that individual case. But we know from experience that individual case will carry with it huge developments for the case at large. It will educate. Attorney generals will watch that, even though they don't have an individual case. They will hear and see the testimony and understand more, and it may inform about how to make some corrections. I think one thing that we deal with in these really large, really complex cases is we all joke about it, like eat the elephant in small bites, like that's how you eat it. Because you just can't, you even though you might try, and there are some really smart people that are working on this case, you just can't wrap your head around all the different ways and directions this can go. So you just got to hunker down and get your evidence, understand what part of the case you're working on, and march forward.
Yeah. All right. So there's one more question I wanted to ask. This was, you brought up some of when you were talking about the origins of the case, you were talking about a lot of the research that was coming around addiction and that you learned from the opioid cases.
We all do that.
Oh boy. But then we also hear stories about other addictions, especially with mobile devices. You have things like mobile gaming addiction or video game addictions that cause microtransactions. We've now got gambling apps on a lot of these phones as states allow mobile gambling. There's stories of internet porn addiction and things like that. So have those companies been sued, or those have, from an addiction standpoint, or do you think maybe they're waiting for this one first and then you might see other lawsuits down the line for some of these apps? Or could we just go after the maker of the phones that are causing these things to be addicted?
There are cases out there. Mm-hmm. They have not sort of percolated up to MDL status. There are state court cases.
Okay.
California has sort of a grouping of cases itself in state court that deal with some of those issues. I don't think anyone's waiting for this. I think some people may have been waiting for Judge Gonzalez-Rogers' decision on the motion to dismiss.
Okay.
If it had been, if she had said there's no case here, that probably would have chilled a lot of the other types of cases.
Right.
But we are seeing really tragic stories about gaming addiction in teenagers.
Right.
And those cases are being filed.
Okay.
We're not at a level yet where you have, a whole bunch of them. Even the companies, you need to know. I mean, again, we run into the problem. Doesn't do you much good in the United States to sue a Chinese company. Not gonna, it's unlikely you're going to recover. Right. Even if you win. So you have to be kind of careful about who the likely defendants are. Right. But the science of addiction and its relationship to gaming apps and the development of the teenage brain and what else it's affecting and different things that are being done with the software or the screen you're looking at, things way more insidious than hiding the clock, where certain colors are put for how many seconds on what portion of the screen it's been determined. Some of that makes it more likely you'll become addicted than not. And some of the companies are doing those studies to determine how do I get folks addicted to this? You know, but of course they're taking the position that addiction's not a bad thing. That's just means you like the game.
Yeah.
So we're going to see. This is sort of a new frontier. We're going to see this. We're going to see more invested in what's going on with algorithms. What is their purpose? How is data being used? I mean, there's another large area of litigation out there that when these companies amass that data, they also sell it, you know, to big companies so that you can be enticed to buy a particular kind of porch furniture or something.
Right.
I mean, it's just, you know, so there are many, and that brings up the privacy lawsuits that we hear about. What can they sell? If you have a medical portal in a hospital to get information from your doctor, even if they don't say what your name is, can they sell the data about you so that you can get, you know, equipment or something that might help you with your disease? All of that is balled up in this sort of new frontier of litigation of products. These are, you know.
So I want to just kind of wrap up. As you're looking at this case, do you ever get a chance to just step back and go, wow, this is a really big case and this is a really important case, and like how does that push you further to drive harder? Or I can imagine just like seeing all this stuff as a wave, and does it weigh down on you at all, or like do you get a chance to step back and go take a break or not?
I don't, not during the case.
Yeah.
It's really hard because we go battle to battle to battle. And so we never know whether the fight over the next group of 10,000 documents we're trying to get is going to have the key to the whole case. So it's just battlefield after battlefield. So you never really get a chance to step back and say, oh my God, like we're almost through this war. It's not until you really get to a place, and I hate to bring up the opioid litigation again, that took a really long time. We're still fighting against some defendants in that, but there did come a point where we had about 23 law firms that were prosecuting that case where we had, you know, we were up to maybe $60 billion going around the country. There were moments then when you were able to look back, when you weren't fighting about some stupid thing. It's like, oh my God, like, I would never have imagined that was going to happen 10 years ago. And
then you started seeing a bunch of movies and TV shows and things like that because of all the information that came out. So I would imagine that at some point we'll see some of this stuff on the social media side, right?
I'm sure we will. And I will say this, that especially is helpful for people to understand. I don't think people understood addiction until we started seeing Netflix shows that were explaining what Purdue was doing and what marketing was happening. Being able to see it, even if it's a fictionalized account, brings it home in a way that sometimes it's really hard for us to do, you know, with an expert researcher and something else. When it gets dramatized like that, it's easier. And we will definitely see that. In my career, addiction has gone from something that only happened to bad people who did bad things. Right. And now that's a complete hogwash, always was. But I've seen the whole public opinion change like that. And I think we are going to see that with social media, at least an awareness of what it can do. But it takes these battles all over the place. It takes you doing this podcast, talking about it. It takes, I'm serious. It takes every little bit helps to raise awareness about what's going on.
All right. And again, I feel like we're still in the early parts of this process. We'd love to have you back on the show as the case develops and you can give us additional updates. What I liked about talking with you is that you were able to explain a lot of these concepts in an easy to understand fashion, especially with a lot of the legalese that happens. When I was reading a lot of the case, my eyes start to roll about how difficult it is to comprehend. But a lot of this stuff is really important, and I hope that people kind of take a look at it and understand what's going on here.
I will say in the documents you have attached, there's no reason to read the end. It's in the beginnings of it. I mean, that's true,
Right.
even for us.
Right.
No need to get into the legal stuff, but the plain language stuff is at the beginning of these documents, and it does a pretty good job of explaining what's going on.
Yep. All right. Again, we'll stay updated with you and talk to you as the case develops. So again, thanks for taking time out of your schedule. I know that you guys have been very busy on this, so I appreciate it.
Thank you very much. Great to talk to you.
All right, that's all the time we have for today's episode. Don't forget to like the video, subscribe to the channel, add any thoughts you have below. Join us every week for new episodes of Today in Tech. I'm Keith Shaw. Thanks for watching.